One Carlos Rios, who's the attorney.
Right here, Your Honor.
All right, I'm gonna ask you the same question that I asked everybody else. Has an acknowledgement of discovery been done, because I don't have it in the court file?
I have signed a few of them at this point,
All right, so has there been any new discovery?
not to my knowledge.
All right, so you can make sure that the acknowledgement of discovery, the state actually has it and the court has it, because it's not in the court file. And Odyssey is doing things on its own. So I'm gonna have y'all come back tomorrow. You're not number one on the docket.
Okay.
There are a couple of cases that are ahead of you, so those cases may end up going before yours. We'll just see where we are, okay?
That's correct.
Respectfully, Your Honor, Mr. Rios always appears, always waits all day. This is impacting his employment. We would ask that if we're not likely to be called tomorrow, that we be released. Additionally, I have experts for this trial that we have attempted to bring in, but we never know, and because the case is older now, when we should bring those experts in. So I'm gonna have to approach the court and request additional funds for those experts if we're reset. So I would ask the court either to give us some preference tomorrow for trial, or if we can't do that, to release Mr. Rios so that he can go to work.
All right, be here exactly at 9:30, okay?
Okay, yes.
All right, I'm supposed to be here exactly at 9:30.
You understand? Now, Your Honor, respectfully, every time we come to court, we lose an entire day of work ourselves too. This is not typical of most of the courts in this county.
Oh, yeah, it is very typical.
It's not.
Yes, it is.
You can say that, Judge, but I practice in
And
the
say
courts.
And it very is typical, because every attorney that's here has a case that's set for jury trial. And this is what ends up happening. What ends up happening is I will allow people to go to civil cases to be out of county, and then their client is sitting here waiting for them. And for some reason, that's the court's fault. That's not the court's fault when attorneys are not showing up at 9 or whatever, and then they stroll in at 9:30 or 9:45. So what I'm telling you all, 9:30, see y'all at 9:30. Thank you. Coordinator will give you a reset form.
Understood. Your
All
Honor,
right,
I'm
thank
trying to
you.
make a record. I don't see the court reporter typing.
What?
Okay, so we only take a record in this court when the judge tells you to? The case was called.
No, the case wasn't called. When I call the case, I call it by the style of the case.
Okay.
All right? All right, so I'll see y'all at 9:30.
Judge, I have to ask you, is this a tactic on the court's part to attempt to wear out the defendant so they can't access their right to trial?
Oh. I find that very inappropriate to say when there is no proof and people are just throwing things out. Now, what I can tell you, and I'm sure your client is aware, sometimes when we end up coming to court, we come to court because there are discovery issues. Sometimes when you're in court, you are in court because your attorney is late. And when I say late, I mean that when a case is scheduled in this court and it's scheduled for 9 a.m. and attorneys go to different courts because they want to go to different courts first, it is not the court's fault that you're sitting here for 12 o'clock or 1:30 or coming back over break. Number one, I have a lunch break. And there was a point in time where I would not take a lunch break. And the reason why I wouldn't take a lunch break is because I said, you know what?
Make a record?
I've been a defense attorney. And when I was a defense attorney, what I would always do, I'm like, I have to be in like 5 courts. It would be nice if they could stagger their docket. And so sometimes I would be here, we wouldn't have a lunch break, and I would be here till 3 o'clock. And then you know what I discovered? When I would say that I'm going to be here till 3 o'clock, I'm working through lunch, other attorneys, you know what they would end up doing? Then they wouldn't show up in the morning. They would just show up at 1:30 or whatever, because they're like, oh, the judge is going to stay there. So I stopped doing that because I need a lunch break. And that's what happens.
So then my other question, I guess, is if you're not doing this to cause the hardship, it obviously causes on all the attorneys and the defendants. Are you doing this for the YouTube? Because we don't have a record, right? Except for the YouTube.
Yes, here's the thing. You're to be back tomorrow at 9:30. You
Yes.
understand?
Yes.
All right, thank you so much. And once you sign the reset form, you'll be here tomorrow. If somebody goes before you, somebody goes before you. Your counsel is well aware, or should be well aware, if he's been practicing in Bear County,
For almost
that
20
there
years.
are a lot of cases that are on the docket for jury trial. So for example, I had approximately 40 cases down for jury trial today. And what ends up happening, sometimes people who are in custody take precedent because their cases are older
I'm
than
asking for a
yours.
record, by the way.
You understand? Because they're older than yours. So that's what happens. So then what
When
ends
things are
up
being paid, there
happening,
should be a record, right?
excuse me, stop interrupting me.
Well, we're not on the record,
Stop interrupting me.
right? I mean, we're not in
Stop
court. if there's no record.
interrupting me.
Sir, here's your reset form at 9:30.
So what ends up happening, sir, is that people who are in custody, sometimes their cases take precedent. And the reason why it takes precedent is because their cases are older and because the jail is overcrowded. Now, as you may or may not be aware, I call the docket all the time at 9 a.m. And sometimes when I call the docket at 9 a.m., defense attorneys are not here. Your attorney knows when he has not been here at 9 a.m. and then you have to wait. And you
Judge,
need
you're
to
aware
be
that every
here,
court starts at 9.
and you need to
I have
be
other
here,
cases.
and you need to be here at 9. So when your attorney is somewhere at another court, you know what ends up happening? Your attorney has made the choice to have you sit here and go to another court before
Well,
coming
that's not
here.
exactly true
You
because all of
understand?
those courts got
All right,
business
good luck to
accomplished.
you.
All
Thank
of us
you.
got
Thank you,
recalled
sir.
today,
Thank you,
right,
sir.
Judge? So, I mean, what did we
Have
accomplish?
a nice
today?
afternoon, sir.
I
Sir,
mean, that's the reason I don't come to your court at 9, because I know in another court,
Sir,
something's
here's your
gonna actually occur.
sir,
And they're courts of exactly the same
Sir.
jurisdiction.
right this way, sir.
Yes. All right, thank you. Hi. All right, Mr. Guzman.
Yes.
All right, so before the interpreter came, and correct me if I'm wrong, your attorneys came forward to let me know that they just received a new indictment. Is that correct?
Yes, Your Honor.
All right, and so that indictment, excuse me. Step away.
I was doing what the court ordered me to do and checking on the discovery.
All right, so what ended up happening is your attorneys, all right. One things have really changed the way people treat people, which I find very odd. All right, so anyway,
Yeah. Okay. Go.
Will you hand me my screen box?
Now go. Preach. Rah.
Arbor Meadows versus Frederick Hagan and John Hagan.
Morning, Judge. Brent Tanger for the plaintiff.
Morning, Judge. Lawrence Margolis for the defendants.
Morning.
I did have a chance to speak to counsel here, Judge, and
How'd that go?
I don't think we're going to be able to resolve anything today. So at this point, we just
What are
need
the
to-
issues?
Pretty much the issue Your Honor identified earlier, whether there was any illegality involving a gun and whether it was a breach of the lease agreement. I am seeking to convince them that it wasn't. He was courteous and asked me if I needed any additional discovery. I don't believe I do. I did get the documents or the video from Pittsfield Township. I think the lease speaks to illegality. It was not a brandishing incident, no pointing. The victim or the person that was mowing or doing the lawn said he wasn't in fear. He didn't feel threatened. So I had sent that to my adversarial, his predecessor, a different attorney from the office, and I didn't hear back. I was hopeful today we could come and it would be resolved, but it is not.
So there is not a dispute that there was a gun. The
Correct.
question is was it brandished or involved in semi-illegal activity?
Was it a violation of the lease? Correct.
That's the issue, Judge.
Is there a CPL?
He does not have a CPL, but he was lawfully possessing the firearm in the sense that he never left his home. It's an open carry state.
He was outside.
He was in his doorway.
I think you might have an issue there if we're talking illegality. If he doesn't have a CPL, if he crosses that threshold. But I don't know what the video shows.
We are going to keep working to try to get it resolved.
Well,
I understand settlement conference today.
yes, it is. And so the question becomes, I mean, did the gun, he did not, as I'm understanding it, maybe I'm wrong, but he did not leave the premises.
That's correct.
However, the weapon may have crossed the threshold.
I don't believe that's the case. I believe he was in the doorway, standing in the doorway inside his own house, and the door was open. And then he went back inside.
Where's
and
the
that was
video?
it. There's no video of the gun. The video talks about the statements from the witnesses, as well as Mr. Hagan.
So but where is the video? Is it?
The video is a Pittsfield Township Police video. I have it. I can send
Right.
it.
Okay.
Yeah.
And the video doesn't show the gun?
It does. No, I don't believe the video does show the gun.
I think that's correct, Judge.
I mean, I know it doesn't show the gun. I don't know about it once they went and got it. I believe they took it after the fact. So there is.
And okay, folks, so why did they take the gun? If your position is that he was in lawful possession of the weapon
Sorry, they
inside
didn't
his
take the
premises,
gun, Judge. I'm sorry. That was different.
they did not.
They
take
did not. Sorry, Your Honor.
All right. How many witnesses do you anticipate?
One for defense.
What's that?
He asked for how many witnesses you anticipate.
At least one, Judge. Potentially more. Our property manager, and could be a few.
Which particular provision is plaintiff relying on?
It's 43. It's in the handbook, section 43B.
I don't have a copy of the handbook. What's it say?
You want me to approach?
Well, what's it say?
Residence tenancy will be terminated if resident, a member of residence household or guest, whether in the home, on the site, or anywhere within the community, engages in or allows any illegal activity. And it says including but not limited to burglary, prostitution, criminal street game, threatening or intimidating assault, brandishing or display of firearms.
So it isn't the illegal activity. The question really is whether or not the gun was brandished or displayed.
I read that as being part of.
I understand how you might read it. It says very clearly brandishing or displaying a weapon. So if that's the case, if he came to the door and the weapon was displayed, it may be a violation of the lease.
That's our position.
Are you seeking my response?
If you have one.
Or were you going to continue speaking?
Well,
We believe it's within the illegal activity. And then it says what?
Read this section. It says brandish, which is common in most leases. The brandishing or displaying of a weapon. So it doesn't even have to, I mean, at least arguably, it doesn't even have to get to the illegal portion. Brandishing has its own definition, but brandishing is more one of this kind of display plus, I'll put it that way. But just the displaying of the weapon. So that's the problem.
I mean, if you're respectfully, if you're going to read as any display of any weapon, this would say that if he had a weapon on the wall, he's displaying the weapon in terms of a strict interpretation of that. I would suggest, because everything mentioned is illegal after it allows any illegal activity. And then it talks about
There
those.
would be no reason to distinguish between brandishing and displaying if it weren't the intent that displaying is something separate, which can cause a lease violation.
I think it's going to be context driven, Judge. Like what counsel's indicating, obviously that's a completely different context than what is indicated here by these circumstances. Something on the wall obviously is not the same as what happened
So
here.
my question, what does plaintiff want? Do they want him out? Do
Correct.
they want is there a way to resolve this by indicating that the defendant will not possess any weapons?
We
Will
just want
surrender his weapons?
Yeah.
Have those options been explored?
They have not sought to explore those options. Initially, we were under the impression, we did speak with the individual, Mr. Levine, and he had spoken with the property manager, and we were on board for a resolution, but I think it came down from the corporate office that there will not be a resolution, and so things changed.
All that I know is that my client right now just wants possession based on these circumstances, and they want this particular gentleman out of the community. So if we could do some sort of resolution, it would be more along the lines of time to move, things like that, is what my client's indicated.
And I said, he's been there for 20 years. He's still in the property with his children who grew up in that home. He's had no trouble over the years other than some minor issues that were resolved without.
But plaintiff, I think one thing that you may need to think about is it's not as though he doesn't have a right to have the firearm. So it could get into a situation where the court potentially could find that whether it be a Second Amendment right or whatever to possess that firearm, they get nothing. I mean, the reality of this is what plaintiff doesn't want is plaintiff doesn't want him coming to the door with a firearm. Right?
Yep.
So I think there's a way of resolving that in that he can forfeit his right to have and or possess a firearm on the premises. So here's what I think. I think I'm going to pass this case, much like I had to do with Mr. Hamden, and I think you guys should go and talk about it, given the context of what the court just decided as to the potential risk for each side regarding the case. Thanks.
Thanks, Judge.
Rubber Meadows versus Hagan.
Hello again, Judge. Printing for the plaintiff.
Larry Margolis for the defendant.
Okay, where are we?
We did have a chance to talk, Your Honor, and I believe that we can resolve this with a conditional order of dismissal, essentially where the terms will be that no community rules and regulations can be violated for the period of at least a year from now. Otherwise, an immediate order of eviction. And also we would have to have some sort of prohibition on firearms, because my client wants it on the record that the biggest concern here is just the safety of the community. I mean, that's what this is about. It's not about this particular defendant. It's about, we can't have incidents with guns. It's that simple. But if we can get a resolution with, that, then I think we'll be okay. So I think procedurally, maybe we can just put this hearing out a week, and then in the interim,
Hold on a second. What's your posture on this, Mr. Margolis?
We agree in form and theory to everything he stated.
I don't know what the heck that means.
I don't either, because it was a very vague sort of proposal. What it is they are going to list some conditions that are agreeable. It's like a super strict probation for 1 year.
Right.
And they're going to delineate specific provisions in the lease that my client, who is not admitting that he had committed these breaches, but that'll be reaffirming with clarity exactly what is expected.
Okay,
That's
we
correct.
got here because of a firearm.
Correct.
The major thing, it seems to me, to the plaintiff is going to be your client's possession of a firearm.
He agrees to not display. He just agrees to not carry. He agrees to lock up any firearm.
There have been a few other issues, Judge, mainly just maintenance. So we'd probably have a few references to that.
Right, I get that. So I guess I want to get clarified what brought us here. So is it plaintiff's position that he could still, if he had the firearm locked up, could have the firearm on the premises?
We would prefer the firearm to not be on the premises, Judge.
And that, to me, seems to me, while there are other issues, is going to be the big logjam.
If we
Mr.
can
Margolis,
circumvent-
is your client willing to voluntarily not possess a firearm?
This was not, when we spoke in the back, this was not made a
Okay,
condition.
but I
of it.
am making it an
Yeah.
issue.
I don't know.
Go talk to your client, find it out.
He says he is. Yes.
So plaintiff's position would be that he not have a firearm on the premises. He's willing to surrender his right to have a firearm at all on the premises. There are some other issues. You guys can get those details hammered out in a week.
Yes.
I think we
Good,
can.
then I'll adjourn this to the 17th, 9 a.m. in person. Come back with a COD for me.
Thank you, Judge.
Thank you, Judge.
Avondale Management versus Francisca Burks.
Yeah, good morning, Your Honor. John Evanchik on behalf of the plaintiff.
Good morning, Your Honor. Jamala Gordian. Francisca Burke. We represented ourselves.
All right. Where are we in regard to this case?
So, Your Honor, I filed a motion to dismiss. I'm not sure if that came into your chambers yet.
What's the basis of your motion to dismiss?
The fact that the water bill is what I'm being charged for as non-payment of rent. The water bill is high due to a broken wax ring in the toilet. As per a contractor that Ms. Jelani hired, who stated that this is the cause of the entire problem, and that's never been fixed. That was the first time when the ceiling collapsed, they figured this would happen. So a year later, this was not professionally done. She dismissed this contractor because she didn't want to get it done right. She hired a family friend who did not fix it right. She did not replace the tub or the toilet or fix the wax ring. So because of that, as per his expertise, he stated that,
How much is owing?
I'm sorry?
Your Honor, if I may, these two cases were consolidated. There was originally a non-payment case, and then there is a termination of tenancy case as well. Quite frankly, we're just looking for possession back, and I'd be more than happy to dismiss the non-payment of
And there's
rent.
no lease,
The lease expired in May.
so there's no lease.
We're at a month to month, and I want to leave. I can't leave because work is being done.
Says what?
The work is being done in the home, and there's mold in the home. I put that all in the case that
I understand that, ma'am, but what they want is for you to vacate the premises. And so you're telling me you can't leave because why?
because there's mold in the home and it's not safe to go in. There's no movers who will go in there. I don't want to stay there, but I can't get my stuff out because when we left, everything was just as it was. And it's been that way since August. Till today, work is not being done. If you go in there, from what a mover I did send over there saw, it's the floors are missing. They're like, they're not going there. It's not safe.
Your Honor, a little context maybe to help the court. If the court recalls, back in August, there was a loss at the premises. The defendants vacated. The only thing remaining really is their personal possessions. And that's really all we're trying to get is their personal possessions.
And I can definitely do that as long as it's safe to go in for someone. I'm not gonna get sued for,
Well, who said it's unsafe?
a couple of things. There's a sticker on the doors.
What sticker?
There's a stick,
If I may, Your Honor.
there's a sticker on the door by the fire chief. Do not enter the property unless you're working on it.
Correct.
Right,
Which means that you can enter the premises.
right. They can enter the premises to do work or to move, but companies are not willing to go in like that. I had one company call before.
This makes no sense to me.
They won't go in.
Disagree, Your Honor. If, again, some context, when the loss occurred, they shut off the water because it was a water damage issue. The water and
I
that,
don't even need to know that.
okay,
When are you gonna get your stuff out?
As soon as they're done working on the property. Or as soon
No,
as it's safe
it doesn't work that way.
Okay,
You've got to get your property out.
absolutely, but no one will go in there and take it out because of the status of the home.
Who,
Your Honor, my clients don't even have keys. The only keys.
There's
are
a
in
lockbox on the
that
door.
defendant has.
And she has access to the property.
She doesn't, my client doesn't have any access. We're just trying to get the property back.
And I will gladly give
why
it,
are you guys talking over each other?
I'm sorry.
I have repeatedly requested just a date or a time frame to get stuff out, and I'm still not done.
When there's floors, then people can go in and take stuff out. There's no floors to walk on. And there's
How much property's in there?
a lot, my whole house, my whole life, Your Honor.
So what would you do if I said they can move it out, put it outside the premises, you got to come get it?
That wouldn't be fair. 'Cause
Pardon? That what?
It wouldn't be fair because
It wouldn't be?
my whole life is in there, Your Honor. I have to pack my stuff, my children's stuff. People just coming in and just taking your stuff out.
But you can't just sit there and not do anything.
I'm not, sir. I'm looking for someone who is willing to go in there and remove my item.
Then what you need to do
Okay.
is I'll pass it, take a break. You need to call. I want to know who you called. Find somebody before you leave here today.
Thank you, Your Honor.
Where to pass it?
So I have to have my stuff out by today.
What did I just say to you?
He said, find somebody.
You need to call somebody. You can use your phone, look up whoever you got to look up,
Okay.
call them, find somebody that's going to move your stuff and when they can do it.
Okay, thank you. All right, thank you.
And then I'll call the case back up, but don't leave the building until such time as I tell you can leave, because we're going to get a date today. That was fun. Okay. Avondale Management versus Burks.
So I did call. Oh, can I speak now? or-
Take your appearances.
Continuing appearance of John Evanchik on behalf of the plaintiff, Your Honor.
Your names.
Demo on board.
Thank you. Go ahead.
So I called several companies and they posed a very valid question that I forgot to bring up. Where will you be taking your items to now? I don't have any place to take it because I'm displaced because of the landlord's negligence to fix the housing, the ceiling collapse. So I'm in a hotel with 4 children. I have nowhere to take it. That's one thing. I need time to find a place. I've been looking since May and even more now in August, and nobody wants to rent with me because they're like, you have an eviction. So I did ask though, I said, well, if I had to move the stuff, could you come? There's mold present. 2 men in a truck said, no, they're not doing it. I can call, put Debbie on the speaker. This side up moving said, absolutely not. That's via text because of the mold present. A third party, he says, he has to see how bad it is, but with mold, he can't send his guides in there.
Which township is this in?
Superior, Your Honor.
Superior Charter.
If I may, Your Honor, my client would be happy to give 30 days to get their stuff out, and after that, the writ would issue. There's some other options we can put on the table here to get this over and done with.
I need to be able to find a place to stay. I can try. I don't know.
Okay, so here's the problem. You got to find a place.
Yeah, I've been trying, Your Honor.
No, you got to find a place.
I
Because if you can't find a place,
So understand what will happen.
Okay.
What will happen is I will set this for trial. If you lose that trial, it's not gonna, all of these questions aren't gonna matter, because what will happen is I'll give them the authority just to put it out on the curb.
Your Honor, I need more time than 30 days to get out of there. It's not like I don't want to be there. I need to find. I don't want to go to trial. I really don't. I want to be done with this, but I need to find a place where the rent is. If there's something given to me.
Have you asked them how much time they'll get? They are saying 30 days. Have you proposed anything to them about time frame?
Yeah, I've told this to Mr. Evanchik. I've told him that what's going on. I've been in conversation with him. He's just telling me, get out, get out, get out.
Okay, fine. But if he's saying 30 days, have you given him a time frame that you could do it?
He never said 30 days, but I cannot.
Okay, he just said 30 days. Do you have a time frame that you could do it?
I might need 90 days because there's an eviction. If the eviction can go away and I can get something from the court showing prospective landlords that I'm not on eviction, I'm not being evicted, I was never evicted, they will rent to me. My credit is fine. It's not the issue. It's just this fact. I didn't want to spend Thanksgiving in a hotel with my 4 kids or Christmas or their birthdays.
30 days, conditional order dismissal.
30 days is not enough.
With the reinstatement in the event that the,
Your Honor, excuse me, Your Honor, can I speak, please, if you don't mind?
Sure.
Okay, Miss Janet Garden has been staying with us. The biggest problem out of this whole issue is the kids that are involved. And they came out of that house. My nephew was the ceiling fell, almost killed him. She just lost that. She lost one of our child during COVID. So it's been like an emotional roller coaster, a single mom with 4 kids. She's been paying our rent to this, the landlord. I've been helping out this family. And it's just to see when things happen and there's a crisis. Within those crisis time, everything everyone wants in the society is money, 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 money. Not forgetting the people that has been displaced in this situation.
Ma'am, that's not true here because they said, ma'am, that's not true here because they said that they just want the premises.
The guy's been very aggressive. Okay.
What do you guys want to do?
I need more time. I will leave the premises.
Then what I'm gonna do is I'm gonna send you out there, talk to Mr. Evercheck. You guys try to figure out a time.
He's very aggressive,
Your
sir.
Honor,
He's very aggressive.
hold on.
All right, then you're gonna need to talk to me.
Yes.
If
Your
you
Honor.
want the bottom line of aggressiveness, you're gonna have to talk to me.
Yes.
So I'm gonna pass the matter. Have a seat.
Yes, sir.
All right. Court recalls the case of Avondale Management versus Burks. State your appearance, please.
continuing appearance of John Evanchik from Paso Plano.
Jamala Gordon, Francis Cooper.
All right. Okay, folks. So we are not any further along than when I last left you, I'm presuming.
No, Your Honor, I did try to discuss this with, not successful.
All right. And ma'am, what is your, there's no lease.
No.
So I guess the question becomes, why wouldn't I just give them a judgment and give you 10 days to move?
Well, because there was conversation of continuation of a lease prior to this collapse. And if it wasn't for the collapse, I probably would have at this point found a place to stay. And I would not be in a hotel spending thousands of dollars. And we wouldn't be here at all. And there would be no eviction. And I would have been able to get a new place smoothly and have my family safe and happy.
But you understand that I really don't, other than maybe a few equities that fall to your side, have a reason to delay it. I mean, here's the reality of it. The reality is you're going to need to move.
Yes.
All right. So from my standpoint, it's the issue of time. And you're saying you need 90 days.
At least, sir.
Well, that's not going to happen. I mean, I can tell you, I'm not going to issue a judgment for 90 days. Is rent being paid?
No, because the property is not habitable.
Got it.
There is rent in escrow from when this originally started as a non-payment, $2,500. So we would ask that be client.
No. If it wasn't for the landlord's negligence, we wouldn't be here to begin with.
Okay, well, I can solve the escrow issue right now. I'm not returning it to anybody right at this moment. Okay. Because the issue is a move out.
All right, so how much time can you allot me, Your Honor? Because, I mean, there'll be another case with the situation of the housing and all, but right now they want possession. So what's the max amount of time you can give me, knowing that no one is willing to come and move my property? And also knowing that I cannot find a new place within the state of Michigan with the open eviction under my name?
Well, let me answer it this way. I try to resolve these in a fashion where it is beneficial for both parties. All right. And let me ask you this. Would you be able to get this all arranged in 30 days?
No, sir.
All right.
I can, if you will allow me maybe 60 days, that would be more. If I can also get something from the court or the landlord stating that I'm not evicted. So when I do present my application to new housing, I can present that as well.
And Your Honor, if I may, as we previously indicated, we're happy to do a conditional order dismissal to move this along.
Your Honor, how long does an eviction stay within your court, please? Because they do check that.
What do you mean, how long does it stay?
Like if a prospective landlord's realtor is looking at my name or pulling up records to see.
What if they pull it up and they look at it? And what counsel's indicating is if we do this by way of a conditional order of dismissal, then it will look as though the case is dismissed.
Okay.
And then otherwise, it's going to look like there's a judgment or a pending action.
Right. Okay.
If they come in, I will say this, if they come in and look closely at the file, they may see something different.
Oh.
But it will reflect as a conditional order of dismissal. It'll look as though it's dismissed. If you comply with all of the terms and plaintiff doesn't have to then issue the judgment and have you evicted, it will look as though it is dismissed.
Okay. I don't know how that's going to help me or hurt me, but what I would like to ask is, did you get a moment to look at my motion to dismiss? Can we just dismiss it all altogether, being that
The motion to dismiss is denied. There isn't a basis for me to dismiss the case. In
okay?
particular, not the termination action.
I'm sorry.
In particular, not the termination action.
Okay, so the eviction is based on $200 that I did not pay for her to fix the plumbing because the plumbing was never fixed. Until the time that
Ma'am, if you want to litigate this case, then you can litigate it. And you're going to be right at that 10-day period. But if you want to go ahead, you can go ahead.
Well, no, I don't want to be at a 10-day period. I would like to have time to get a company who's willing to move my stuff out with the mold situation.
All right, here's what I would suggest to the parties.
Okay.
That there be a conditional order of dismissal with that the defendant would vacate the premises by January 31st of 2025.
I apologize, Your Honor, I'm not doing the math, but is that more than 56 days?
It is not.
Okay, so we're under 56.
Yes,
I think that works out to pretty close to 45 days.
correct. It's about,
My client's fine with that.
what about you?
Okay. T-shirt. Can I get something next week? I'm sorry, Your Honor, you said.
The January 31st date. Okay.
Now, I think in the conditional order dismissal, it would have to acknowledge that you're not residing in the premises, but that they're and won't reside in the premises.
Sorry, I can't hear you.
That the conditional order dismissal would have to indicate that you're not residing in the premises, will not reside in the premises, but that you have personal property in the or on the property,
Okay,
and that the personal property would have to be removed by defendant prior to that date.
okay,
Okay,
okay.
just so that we make that clear. All right. Also, in the conditional order dismissal, the amount held in escrow, that the court will rule on that issue after the defendant has vacated the premises,
Okay.
as to where that property would go or where that money would go. And I can give a court date for you guys to come back. I need a court date in February.
February 4th at 9 a.m.
And that there's a hearing set on the escrow for February 4th, 2025 at 9 a.m.
Do we have to be here in person, Your Honor?
You'd have to submit a form to appear in Zoom.
I'm sorry, sir.
You'd have to submit a form if you're going to appear by Zoom. I'm not guaranteeing that I would say that you can.
Okay.
If you have if everything is out of the property, I'm going to be much more inclined to let that happen.
Sounds good to me. Thank you. One more thing. In regards to the mold and everybody denying me to come in because of the mold, is it possible for you to put into the conditional that they can at least show something that the mold has been taken care of? So, because people are going to have to come in and pack my stuff, so they're comfortable doing.
Well, I'm not going to get into that. I will just say this.
Okay.
That mold can appear there's mold everywhere. The question is whether or not the mold is of a type and nature that exposure to that would jeopardize some impairment of human health.
It is.
I don't know that now.
No, I sent you the mold report.
I understand that, but there are differences there are still differences in that. So I am not I'm not here to make a ruling and will not make a ruling as it regards the mold and the like. If the folks that move in go in to move your property have to mask up or do whatever it needs to protect themselves, and they certainly can do that.
Okay.
Because if you don't move the property, the reality is that's precisely what plaintiff is going to have to do in regard to getting the property out of the premises. So, all right. Anything else?
No, if I could just read back through this really quick, Your Honor.
Yes.
And I'm going to be preparing this.
Yes.
So, defendant to vacate on or before January 31st by removing personal property possession. Defendants have already vacated the premises. That the court will consider on 4th, 2025 at 9 o'clock in regards to $2,500 that escrowed. I assume that if we are able to reach resolution ahead of that, then we don't need to come back.
Correct.
Okay, so I will draft this up and submit it to the court, or a copy of post at the time.
All right. Very good.
Thank you, Your Honor.
Do either of you have any other questions?
No, that'll be all.
All right. Thank
Have
you.
a nice holiday.
Have a wonderful holiday, sir.
You do the same. Court calls the case of Huron Vista Apartments versus Sharonda Hayes. Good morning. May want to take your hands out of your, yeah, you knew it. You knew it. She put her hands in and looked at you and said, "Oop." All right. Okay, where are we on this case?
Your Honor, in this case, plaintiff had filed an amended complaint for both termination of tenancy and non-payment of rent. I had a chance to speak to Ms. Hayes. I believe she wants to address the court. We have not been able to reach a resolution.
Yes, ma'am. What do you?
So when she approached me earlier, I'm sorry, got a little anxiety behind this right now. I noticed, I asked her, did she get a chance to view the letter, the email that I sent to both court and Attorney Fink? And also, did she get a chance to view the video? She said she didn't get a chance to view the video and that she would view it shortly after she just got done talking to me before you even came into the courtroom. So then she reapproached me and asked me, well, letting me know that they would give me 30 days to move and that it would not affect my Section 8 voucher. Did I have a place to go? When could I move or whatever? My thing is, I asked her about what was the reasons behind me getting evicted, because clearly everything that happened as far as me calling Section 8, telling them about repairs that needs to be done, was all done before this incident happened in October, as well as the snakes on my porch, all different things that I already had mentioned in that letter. So I wanted to know that, and she said that it wasn't nothing wrong with my unit or something like that. Section 8 letters to reinspection, they came out twice. They gave them a certain date to go in there and fix it, which was by November the 8th. They never came. And then all this transpires. So I'm just a little lost. Like, if they attorneys even read the complaint.
Well, but hold on a second.
Okay.
How much is owing in rent?
$875. That includes the court costs. Your Honor, I do just want to address one piece. So I have spoken to my client. The rent has never been abated. Section 8 did come out and they did do an inspection. They found nothing wrong.
It's on the back of the form. And I sent that to the courts. They came out twice.
Okay, but they didn't abate the rent.
No, but when they came out October the 6th, because I called them in September to let them know that I was not working because I'm partially paralyzed on the left side. So I was not working at this time. They came out October the 6th to do the first inspection. Then they came back again, which was November.
But they never abated the rent, man.
Right, but on the back of the form, it said that Huron Vista needed to do the repairs, and they list 3 different repairs that they needed to come in to correct and fix. They never came. So I was just, I'm just trying to figure out how did they come about that. And I even questioned Section 8. I also wanted to know why my key fob was deactivated. I even asked Section 8 that. They said there should have been no reason that my key fob should have been deactivated. And on the video where I had the confrontation with Mrs. Lewis, as we got down to the bottom of the stairs, I asked her again that, my key fob, well, I pretty much told her that my key fob needed to be worked.
Ms. Hayes.
She told me, can I say something?
Ms. Hayes.
Okay.
What's the real issue?
The real issue is that I'm trying to figure out how I'm in the wrong when only thing
Okay,
I did was.
let me ask you this.
Okay.
Do you have the $875?
I don't have it right now. I did contact Hawk. They held back because.
Okay. Hold on.
And if I can't, I can.
Let me
get to somebody.
Hang on.
Okay.
If she pays the $875, can she stay or no?
No, Your Honor.
They want her out.
Yes, and Your Honor, the issue is related to any time there has to be any kind of communication with Ms. Hayes, whether it's for maintenance to come in or whether it's related to a key fob. It is a very threatening type of interaction. And there's video, I mean, she even submitted videos that show that. So it's not a good situation. And plaintiff is willing to work with her to help her, they don't want her to lose her voucher or anything like that, but to move on to somewhere else to a better fit.
Can I say something or
Go ahead.
okay. Your Honor, anytime, if they look at the other video, anytime I had an interaction with,
But hold on,
I'm sorry.
hold on,
Okay,
hold on. We can go back and forth and everybody can have their interpretations of it.
okay,
Here's a jeopardy for you.
okay,
Let's say you go to trial.
okay,
I find that they're proper in terminating your tenancy.
okay,
You have no voucher.
okay,
And then where are you gonna go?
okay.
Okay, what?
I'm sorry, I didn't hear.
And then where are you gonna go?
At that point, I'll have something in plan. I'll have time.
Okay, so
to
Ms.
think of
Hayes,
things.
Ms. Hayes, you don't have a plan in mind.
I kind of do,
Is-
but I just don't.
Okay, well, what's your plan?
I'm saying at this point, it's if I have to move, right, I have to move. So it is not a really plan. Like I'm not gonna sit here in the courts and say where I could go to or where I can't go to. It's just the whole fact
Hey,
that,
Ms. Hayes,
Mhm.
let's do the reality.
okay,
If I said you have to pay the $875 and you have to do that within 10 days, I just give them a judgment for that.
Mhm.
You've already told me you don't have it.
right.
And so then they'd be evicted.
I'm not saying that
Yeah.
I don't have it myself. I'm sorry, Judge. I just wanted to explain what I was saying when I said I
Okay,
don't
so
have.
what do you want to do?
I don't want to be evicted or have to move because I feel like I haven't done anything wrong. Yes, I had an issue on that video because the way they approached me. Okay, if I have to get the money,
But what if it turns out that's enough?
huh?
What if it turns out that's enough?
That's enough.
Then I give them a judgment, you're evicted, you lose your voucher. Does that make any sense?
I understand what you're saying. But in my heart, I feel that none of this should have happened. I don't feel like I was wrong by asking why my key fob was.
You know what, Ms. Hayes, what seems to be more important to you is, which I can see how there would be a confrontation sort of dealing with the landlord is you want to be right.
No.
And you want to be right almost to the point that you may jeopardize your housing or future housing.
Okay, I understand that, but I'm not saying that I want to be right. I just wanted to come to some terms where I'm defending myself against what was going on. I don't have to interact with them. I can pay my rent online. I don't have to go into the rental office for anything because I really wasn't. Only time I went in there if I had a problem with my mail or when in the beginning when I'm signing paperwork. So it didn't really happen. And then I didn't have any other maintenance problems except for when I called Section 8. So it was a never issue with maintenance not being able to enter in my unit. That's all I wanted to explain. There was never an issue. Me and the maintenance guy used to be cordial all
What do
the
you
time.
want to do? Because you're going to have to make a choice.
Okay.
I mean, we can go to trial on this. And the downside of that for you is if you lose, everything's gone. Your apartment's gone, your voucher's gone, everything's gone.
Okay. And how does that work? How does the trial thing? Because I've never been in this situation. So I'm just trying to figure out how does that
I'll
work?
give you a trial date. And then you'd come in, you'd have to present your evidence, they'd present their evidence, and I would make a decision. And if I made that a decision against you, you lose all of those things.
Okay. And then so how, like,
And even if I were to rule in your favor, you'd have to pay the $875, which you don't have.
but I can borrow it if I have to. That's why I was trying to explain to you. I don't have it myself. But if I have to go to people to get it, I will. I did have the thing with Hawks. I sent them an email letting them know that all the adjournments, and she told me to get back with her.
Did Hawk say they'd pay?
Yeah, but they didn't know what was gonna go on here. They did speak to Alex of legal service.
Did they say they would pay?
They said they would pay, but they needed to know the outcome of this. If I was getting evicted, then it wouldn't make no sense, I guess, right? So then they said for me to keep her updated, which I did. I emailed Alicia. I'm sorry, over the weekend when I got the second
Ms.
judgment
Hayes,
saying.
if you had to move, you don't have the funds to move either, do you?
I mean, to another unit, to another place.
Listen to my question.
Okay.
If you had to move, you don't have the funds to move. Right?
I don't have the funds moved. No, I don't. I'm not saying that I can't ask somebody. I do have family. You know, I can ask. I'm sure they're not gonna let me be just out here and not have a place to stay. Or have means to move if I have to move, right? So that's all I'm trying to explain. I don't have the funds myself. And I mentioned before.
What do you want to do?
I'm just trying to prevent myself
And that's what you're trying to prevent.
No,
I asked, what do you want to do?
I don't want to move.
So you want to try.
Yeah, I mean.
And then if I tell you you have to move, you have to move.
Correct.
And you're not likely then going to have your voucher.
At this point, Your Honor, this part.
Ms. Hayes.
Yes.
As between you and your landlord, it's not working. Right?
Correct.
Okay. So why would you want to be in that predicament?
I don't want to be in that predicament.
Just
okay.
listen.
Okay.
Wouldn't it be better to try to work something out where you can get yourself someplace with your voucher
and
be able to work with your landlord and not have to worry about it? Wouldn't that be the best thing?
Yes. And
then why don't you talk with Ms. Gazzari about a plan to do that?
Okay. Your Honor, I'm sorry.
Go ahead.
Can I say something? What I'm trying to explain is, as I written in that letter to their attorney was, or addressing the courts was that, I at least wanted to try to finish my 1-year lease out, which when I said that was so that I could protect my voucher. I didn't explain it in there like that, but that was so that I could protect my voucher. My lease is up at the end of May. No, I don't want to stay there no longer than that because of the situation. But at the same time, I'm in a situation. I'm going through stuff medically. It's the winter time. I don't have time to be trying to figure this out to move. And so when they came up against me, it just made me feel some type of way. So that's why I'm just saying, no, I don't want to be there no longer than try to renew my lease with them. But I feel like this was a retaliation. So it's forcing me to leave earlier than what I would. It's going to be winter time. But if I have to, I have no choice.
So you don't really want to be there?
No, I don't. Not after everything.
All right, stop there then.
Yeah.
Then figure out a way to move, retain your voucher, and move on.
I get that, Your Honor, but 30 days is not enough time. She's saying all they can offer.
How much time are you saying that you need?
I'm not sure how this works. This is my first time, right? So I would have to ask Section 8.
If you know 30 days is not enough, how much time do you need?
At least 60 to 90 days, because I have to have Section 8. They have to send in the paperwork, how that goes, and find a place, get approved for a place, all this stuff. And so that's 30 days is not enough of a time to do the whole.
So let me ask you this. When you talked to Ms. Gazzari, did you ask for more time?
When I talked to her?
Yeah.
No, because she just blatantly said that.
Okay,
we're giving
but
you
did
30
you?
days. She said we're allowing you.
Did you say what you needed?
I told her I couldn't make a decision because I wasn't sure at that time. That's what I just told her.
Okay.
I said I would come and talk to you.
So, but, right. But so now what's clear to me is you want to move.
Regardless of what the situation was gonna end like, if I was gonna still be there to the end of my lease, I was not gonna resign with Huron Vista, is what I was saying. So
Okay.
I do want,
So we're past that because
Yes,
what
sir.
that tells me is you want to move.
yes, I do want to.
Okay. So now the question becomes the timing of that move. Right?
Right.
Okay. They have told you they can do no more than 30 days, right?
That's what she said.
And then, okay. Did you give a counter proposal to them as to how much time you think it would take you to do it?
No, and kind of yes, because she just asked me right before you came into the courtroom, Your Honor. And so
Ms. Hayes,
I just told her I didn't know.
Ms. Hayes,
Okay,
we've gotten to a point, you don't want to be there, they don't want you there.
correct.
Run into that all the time. Not a big deal. You've got things that you need to protect for you and your future.
Correct.
So why don't you go out and try to work out a time frame of a move?
I have no problem with that.
Okay, Ms. Gazera, I'll pass the matter. Let me know. Let's come up. Okay. Here on Vista versus Hayes.
Marissa Gazari, appearing for plaintiff.
State your name.
Sharonda Hayes.
All right. All right. Where are we on this?
Your Honor, we're very close, I think. So are you okay with, are you okay with me telling you the judgment issue? So plaintiff has agreed to allow 60 days, so essentially until February 10th, 2025 for Ms. Hayes to vacate. So Ms. Hayes did contact CMA when I was in the conference room with her. So the issue that she has is that CMA is indicating that she can't court her voucher in the middle of a month.
In the middle of a month. Right.
And I don't have approval to go through the end of February. I can get through the end of January if we're talking about through the end of a month.
Okay. So she can't move her voucher in the middle of a month. So if it came the 60 days, it would actually 50 days and 60 days are the same thing, effectively, right?
Yes.
Here's what I might suggest. Maybe if you do the 10th, but if plaintiff or defendant files something with the court could extend it to the end of the month, indicating that she has a place but needs to do whatever. I don't know if that helps at all. Making it that, or while their authority may not be there. Hold on one second.
Your Honor, so I think what you were saying is that she wasn't able to court her voucher by the end of January, that she could file something with the court asking until the end of February.
To defend.
And I think the plaintiff is okay with that as long as all the other terms are being followed of the conditional order of dismissal.
Okay.
Does that work?
Does that work for you?
It does. Section 8, they just they want to have like a definite answer, I guess, from what she told us on the phone. So they got to know if it's the 10th or if it's the 28th. So that's why I was
of February.
Yeah, that's why I was.
Well, but they're in this instance. Oh, I see what you're saying.
Yeah, because
so in this instance, really, what it would be is it would be the end of January, with the ability for you to get the end of February. You see what I mean?
Okay.
Does that make sense to you? Or no? If it doesn't, I'll try to explain it.
I mean, it makes sense, but it's like
if they need a definite date, it would be January by the time you try to do something. But you would have the ability to get the end of February.
Okay, because I guess Section 8 was trying to explain to their attorney that they send the payment out already.
They what?
Like when they said February 10th, I could have went to February 10th. Well, Section 8 was saying by the beginning of February,
they would correct. And so what it is that the agreement actually is going to have to say January. But then it's going to be on you if everything's not ready for you to get that extra month.
So do I do that like,
You file a motion with the court, you file just a paper with the court indicating that you need an additional month. That's all it needs to say on there.
okay, but when do I do that? Like, well, like, just kind of estimate like when.
You would do that sometime in January if you're unclear that it's going to happen. So you would want to be able, I'd say by mid-January, you want to do that.
Okay.
Okay, if it doesn't look like, it looks like you're going to need that month, by mid-January, you're going to have to do that so you can get on my docket. So that I could do that, okay?
All right.
All right.
All right.
And when you file that, you got to make sure to send a copy to the plaintiff's attorney.
Okay.
All right. And given what we said, they may just agree and it doesn't need to come to me that you get that. Okay.
Okay. And is there a court document I have to get or just?
To file?
Yeah, it's like.
You're just trying to do everything proper.
Well, I just.
If you come up and write that on a piece of paper with your case name.
Okay.
With your name and a case number.
Okay.
It will hopefully get to the file. But but the good thing is that if you do that here, they'll get it to the file. And then you can also, if you send it to plaintiff's counsel, then they have a copy of it so that they know exactly what's going on.
Okay.
Make sense?
Makes sense.
Any other questions you have?
Oh, Your Honor.
All right. So how we're going to do this in the form of a COD?
Yes, Your Honor, if I could place all the terms on the record.
Yes. Go ahead. And Ms. Hayes, doesn't it go a lot better when you kind of actually talk things through and work it out? Huh?
Yeah.
Right?
I'll just say yeah, because I can say something else. But yeah.
No, I still say you can have issues, but this at least gives you some.
Yeah.
It gives you more space to try to work.
Yeah, I agree.
You see what I'm saying?
Yes, sir.
Oh, okay. Go ahead, Ms. Cassar.
Your Honor, so as of today, the outstanding balance that's owed is $875, which includes the court costs. Ms. Hayes may continue to reside as a leased premises. Until January 31st, 2025, provided that she complies with the following terms. So she shall vacate the lease premises by that date and also return keys to plaintiff by that date. In the event that, in January, she realizes that she's not going to be able to find some other place, she does have the ability to file a document or a motion with the court and copy plaintiff's counsel that indicates that she needs till the end of February, and plaintiff is willing to allow that. That would extend the move out date to February 28th, 2025, as long as she's still complying with the other terms of this order. She shall pay that outstanding $875 by February 10th, 2025. I understand that she's going to get assistance to try to pay that. She shall also pay her monthly rent for January timely, which includes her washer dryer fee. If the move out date is extended to the end of February, she'll also pay timely rent for February as well. She shall comply with the terms of her lease, and she will allow maintenance to enter the unit to make repairs if needed. In the event that she fails to comply with the terms of this order, plaintiff may submit an affidavit of noncompliance to the court together with an immediate judgment and immediate order of eviction. Notice will be sent to Ms. Hayes via email and mail. And the email that I have is survivingipsilani@gmail.com. And then there wouldn't be any hearing. In the event that she fails to move out, the 56-day rule is waived. The 14-day notice of objection rule is waived. Plaintiff agrees to provide a neutral reference for Ms. Hayes if contacted by a prospective landlord. The time for obtaining an order of eviction is extended from 56 days to 185 days. What else? Neither party is waiving any claims or rights under the lease or the Landlord-Tenant Relationships Act, except as specifically set forth herein. The terms of the lease agreement remain in full enforcement effect. Neither party or nothing in the order should be construed to be an admission or finding of fault on the part of either party. And if you can explain the 3-day rule.
Right. Is all of that correct, Ms. Hayes?
Yes.
All right, very good. And then if it complies with that, you would give Ms. Pizzeri the right to sign your name to that conditional order dismissal and submit it to the court?
Yes.
All right, very good.
Hey, one piece. So we originally had a move out of February 10th. So that's the date that I made the payment due. But if you're moving out at the end of January, can the payment be due January 1st?
Guys, I don't have no choice, right?
They're not gonna, I mean,
No.
assistants wouldn't pay, I don't think, if she's moved out.
See, I don't know how that works.
Right. If it's going to have to be because assistant, if you get assistant, it's going to have to be paid prior to your move.
Right.
Got it. So it would make sense to change it to the 31st if you don't have a problem with that.
Okay, so I'm changing to January 31st.
All right.
Okay.
All right. I'll indicate that this is settled, conditionally dismissed. Thank you.
Thank you.
Says good luck to you.
Thank you. Have a blessed holiday, everybody.
All right. 14A District Court for County of Washington State session is now in session. The Honorable Judge Jason presiding.
You may be seated. Court. No, you didn't expect me. I know. Seriously? Why is this happening?
I don't know, but it's really odd because you are in Zoom. That's weird.
I'm in Zoom.
Yeah, like I see you.
I'm in Zoom, but yeah, I see myself. That's a pretty guy. So, are we ready now, Emily?
Slay it. Yeah. We're ready. I don't know what's going on with this.
I'm gonna have you speak to Mr. Allen.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is a absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Street, we're going to start bringing people in person. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
No patience left. But trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.